today with the International Criminal Court and prospects in the future. My name is Meryl Sherlock. I'm director of the Justice and Society program at the Aspen Institute. The Justice and Society program has worked in the area of human rights and humanitarian law for over 35 years. Under our prior director, Alice Hankin, we conducted training sessions for judges and scholars in the area of human rights and humanitarian law. And we are continuing Alice's legacy with work now in the area of capacity building and with respect to the international trials. Recently, we had Judge Sylvia Cartwright, one of the international judges in the Extraordinary Chambers of the Courts of Cambodia, for a session here with judges and scholars. We were joined for that session by Ambassador Rapp. We are working with judges from countries around the world, and we bring judges as well as legal scholars to Aspen during the summer for the signature Justice and Society Summer Seminar. I'm delighted that we have such a distinguished panel here today. I will leave the introduction of the panel to Michael Greco, but I do want to introduce Mr. Greco, who is a commercial litigator, an arbitrator, a mediator, and an appellate lawyer with nearly 40 years of experience. From 2005 to 2006, he was the president of the American Bar Association, and during his presidency focused on rule of law and human rights. Currently, he's chair of the ABA-ICC Project Board Advisor and chair of the Advisory Council of the ABA Center for Human Rights. Michael, thank you very much, and I'll turn it over to you.
Thank you. Is the microphone on? Can everyone hear me? Good. Good afternoon, everyone. I'm delighted to see this large attendance. This is going to be a very interesting discussion we're about to have. Since the biographies of the two speakers are on your seats, I'm going to trust that you've either read them or will read them, and I will be very brief in my introduction of these two extraordinarily distinguished individuals. I do want to take one discretion, though. I see in the room so many distinguished guests, and I know that I shouldn't do this, but I'm going to do it, and you'll know why. I want to acknowledge the presence of one individual who's sitting in the front row, Ben Ferenz, the last surviving prosecutor from Nuremberg. Would you please stand, Ben Ferenz? So let me begin with abbreviated introductions of our two panelists. Fatou Bensouda is the prosecutor of the International Criminal Court at The Hague, and she is former Attorney General and Minister of Justice of the Republic of the Gambia. She was elected prosecutor by a unanimous vote of the Assembly of States Parties in 2011, and she assumed her duties in June of 2012. Prosecutor Bensouda has been recognized by Time magazine as one of the 100 most influential people in the world, by the New African magazine as one of the most influential Africans, by Foreign Policy as one of the leading global thinkers, and by Jeune Afrique in 2014 as one of 20 African women who, by their actions and initiatives in their respective roles, advance the African continent. She was the consensus choice for prosecutor by the African Union. Richard Goldstone currently is distinguished visitor from the judiciary at Georgetown University Law Center and co-chair of the Human Rights Institute of the International Bar Association. He served as the chief prosecutor of both the UN International Criminal Tribunal for the former Yugoslavia and Rwanda. He has been Justice of the Constitutional Court of South Africa and a member of the International Group of Advisors of the International Committee of the Red Cross. With that, we will begin our program. Our format will be this. It'll be conversational. I will ask one question of each of the panelists for a time, and then I will ask questions that both of them will respond to. We will leave time at the end for good questions. We had a good number of them at the last program, but there will be time. So if you have something you want to say or ask, save it until the end of the program, or end of the presentations. My first question is directed to Madam Prosecutor, after a sip of water. Madam Prosecutor, in your opinion, what today are the main challenges facing the Office of the Prosecutor at the International Criminal Court and the ICC, and how will the challenges be overcome?
Where do I start? Good afternoon. I'm very happy to be here with you this afternoon. But coming to your question, I think that the court and the mandate of the court, by virtue of the very mandate that the court has, we will face challenges, inevitably. It has to happen. But I think that some of these challenges can and must be mitigated. The first challenge, if I can start from there, resources. Resources for the court. My office, for instance, we've seen that, and I think everybody can see that, the explosion of cases before the court now, that my office is handling, is not matched by the resources that the office has, or in fact, all the rest of the court that we have. And I think one of the first things I did when I assumed office in June 2012 for the next budget was to bring to the Assembly of States Parties the problem that we have been facing. The office had for a long time, has had this, as you know, the zero growth budget. And meanwhile, the resources have not been increasing, but the cases have been increasing. And what we've been trying to do all the time was to rotate the resources, and move resources to those areas where we think that has more priority. But I have presented to the Assembly of States Parties that there is so much rotation of resources that the office can do. And for us to be efficient, to really be able to execute the mandate that has been given to us under the Rome Statute, we just need these additional resources. And I was able to make a presentation to both the CBF, but also the Assembly of States Parties. Fortunately, and I'm grateful for this, the ASP has given some of what we have been requesting for, but, and we're grateful for that. But I think it has to be recognized that if this institution, if this court is going to be efficient and be able to execute the mandate and do it in an effective way, the resources have really to match the docket, the case docket that we have. Another area that is also a challenge to the office, again, is cooperation. I think now it is quite clear that without the cooperation, and when I say cooperation, I'm talking about tangible and timely cooperation from the states. Without that, it will be very difficult for the office, again, for the court to be able to be efficient and be effective. And what we have been asking of states, what we will continue to ask of state, is that there must be cooperation, but that cooperation should be timely, it should be tangible, it should be substantive cooperation that we should receive for us to be effective. Another challenge that we are facing, which I think in the recent past has really been keeping the office very, very busy, and that's witness interference and witness tampering. we see this now across our cases. In the Kenya case, the level of witness interference has been unprecedented. And the difficulty that we have been facing in keeping our cases together is that witnesses have just been pulling out, either because they're intimidated, or because they're bribed, or for some other reason, or their families are bribed, because it does not just stop with the witness themselves, it extends to the family. And for us to be able to keep the integrity of the proceedings, this has to stop. And I think you will note that we are trying to fight back. We are trying to do what we can by bringing cases, Article 70 cases, obstruction of justice, before the judges of the ICC. In the Kenya case, we've been able to ask for an arrest warrant to issue against Walter Barasa. Kenya is yet to execute that arrest warrant, but also in the case of Jean-Pierre Bemba Gombo, we have had this witness interference, witness intimidation, in which we've been able to also ask the court to issue warrants of arrest against 5 individuals, including Jean-Pierre Bemba himself. So, and effectively what this means is that we are using resources for these cases that probably we should just have been using in our core cases. Our core business is pulling away resources from our core business because it needs full investigations, and if it goes to trial, it needs a full team that should present the cases. So this pulls away resources from our main resources and from doing our core business, and this is also another challenge. Misperceptions, misconceptions is also another challenge that the court is facing. I think one of the biggest enemies, if I may put it that way, of the court is either the misconceptions or the misperceptions, or deliberately, making sure that the court is misunderstood. And for this reason, we need more outreach, which, as you know, we as the court alone cannot do it. We will continue to need help from outside, from states, from international organizations, from civil society, to help get the word out there about what the court can actually do and cannot do. What are the limitations of the court? Where it can intervene, where it cannot intervene. I think these are the things that needs to be out there for it to be understood that the court cannot intervene just anywhere, even though we would probably wish to do that. And finally, politicization. The court has faced, I think, in the last year, always, we continue to operate in circumstances, in political, environments, which is not our doing. We cannot help it, but that is the case. But then the idea of politicizing the court and making sure that any action, any step that the court takes is perceived to be taken because of some political reasons. This is also hurting the court. And I think we have been quite clear. I've always said, and I believe my predecessor was saying it all the time, that these political reasons, this geographical balance, is not the criteria that makes us open an investigation or not open an investigations. As I said, we are sensitive. It's all political environment that we operate in. But I think that if we have used political reasons to move forward, to open an investigation or to close it, or open a preliminary examination or prosecute someone and not prosecute the other, I think it's better for ICC to just close, because that is not what it is set up for.
We will return to the subject of misconceptions a little later, but Justice Goldstone, as former prosecutor of both the ICTY and ICTR, you are among a handful of people in the world who know precisely what Madam Prosecutor is experiencing in her position at the ICC. I'm going to ask you a two-part question. Both contextually and in practice, please compare the ICC's development to that of the ICTY and ICTR at similar points of their development. And the second part is, while your service as ICTY and ICTR prosecutor was most impressive, what advice might you offer to Madam Prosecutor on issues that, in retrospect, you would have handled differently?
Mm-hmm. Well, the first question, to make the comparison between the ICC and the ad hoc tribunals at similar periods, is really, I think, an unfair comparison. I think it's unfair to the ICC for the following reasons. Firstly, the mandate that the Office of the Prosecutor was given by the Security Council in respect of Yugoslavia was to investigate war crimes in the former Yugoslavia. In Rwanda, to investigate war crimes in Rwanda. They were both difficult, complex, but focused. In the case of the International Criminal Court, there's no limit to the number of countries. There are 122 possible countries over which the court has jurisdiction. And it's a much more difficult task for the prosecutor to decide which cases to pursue, and for the court to decide in the case of some countries that approach the court, and we can talk about that later, it's far more difficult. Secondly, we had primacy of jurisdiction. We could decide who we wanted to prosecute. There was no system of complementarity. I'm a strong supporter of complementarity, but we had the privilege of deciding who we would prosecute, and we could trump the decisions of any domestic courts that had jurisdiction. Thirdly, we had no pre-trial chambers. Fourthly, we had no victim participation. So I think the work of Madam Prosecutor is far more complex and multifaceted than the work was of the Office of the Prosecutors of each of the two ad hoc tribunals. Dealing with the second part of your question, and here perhaps it's using hindsight, but not too much. The one question that's worried me particularly with the Kenya investigation, soon after I left office during the term of office of my successor, Louise Arbour, mainly as a result of pressure, political and financial pressure from the United States, a number of Croatian generals and senior politicians voluntarily gave themselves up for trial in the Yugoslavia tribunal. I can imagine the reaction of the then President, Antonio Cassese, and the other judges sitting with him to an application for bail from any of those Croatian generals or officials. I don't believe that they would have for one moment considered letting those people, notwithstanding their voluntary giving themselves up, to have roamed freely amongst the victims and to make the tribunal subject to their continued goodwill. In my view, people who are charged with crimes against humanity should await trial in the court prison and not be allowed free. And it seems to me that it was a costly mistake, using hindsight, not to keep the defendants in the Kenya case sitting and awaiting trial in The Hague. The second and last point I would make in this regard is and here I speak with ignorance, and the prosecutor might be able to assist. Quality control for indictments is crucially important. It was achieved in our office by making all investigation sections subject to the not the oversight but the considered views of all the lawyers in the office. Before an indictment was presented to me as chief prosecutor or to Graham Blewett as my deputy, indictments were for days debated by the lawyers in the office. They were given access to witness statements. They debated whether the charges were appropriate. whether their evidence was sufficient. And certainly from my experience, that control over indictments was the main cause that, to the best of my recollection, no indictment presented for confirmation to a single judge in the ICTY was ever denied. Certainly there were questions asked and amendments were made, but the quality control, I think, guaranteed to the extent that one can that the indictments were appropriate and thoroughly investigated.
Do you care to comment before I ask my next question of you, Madam Prosecutor?
Obviously, we learn from, we have lessons learned, if I may put it that way. And there is an attempt in the office to also do things differently from the lessons that we've learned in the past. I'm sure you are aware of the new strategic plan of the office, which there is a fundamental departure of the strategic plan that we had before. And I think the issue of quality control, coming to that exactly, it's also being thoroughly done. And not that it wasn't done before. I don't want to give that impression, but it is also being thoroughly done. And I think the recent example that we have regarding the Kenyatta case was part of that robust review of the evidence that we have and the case where it stands today, especially in view of the fact, as I mentioned, losing some of these critical witnesses that would attest to critical events in the Kenyatta case.
Okay. Well, my next question for you, Madam Prosecutor, is this. The conflict in Syria has evidenced horrific mass atrocities, the immense suffering of the civilian population, the destruction of ancient, age-old World Heritage sites have captured the world's attention and outrage. Why hasn't the ICC exercised its jurisdiction in Syria?
Because we have no jurisdiction in Syria. Simply.
I'm addressing an unstated misconception in my question.
Yes. Recently, with the conflict for the past 2-3 years, there has been several calls, and several efforts also being made for ICC to intervene in Syria. But the reality of the situation is that we just don't have jurisdiction to go into Syria. ICC can exercise its jurisdiction if that particular state where the conflict or the crimes, alleged crimes are taking place, is a state party to the Rome Statute, or where the crimes are committed by a national of a state party. In those instances, the ICC can have jurisdiction if the crimes take place and that particular state has not been addressing the crimes themselves. Then ICC can intervene. Absent that, the only other way, I think many of us know here, is that there is a declaration made by a particular state accepting ICC's jurisdiction under Article 12.3 of the statute. I think we've seen an example of that in Cote d'Ivoire, accepting ICC's jurisdiction. Later on, of course, it became a state party, but first it accepted ICC's jurisdiction, making us to be able to intervene. Another way which a state not party to the Rome Statute is a referral by the UN Security Council for the ICC to intervene. But I just want to be clear here that even though the UN Security Council may refer a case to the ICC, but of course we have to see that all the legal criteria within the Rome Statute is met before my office can intervene to investigate. In the case of Syria, as I said, we just don't have jurisdiction to go there. Syria is not a state party, and we can't go there, unfortunately. And of course, this is not to say that we do not empathize, as human rights activists, as we do, what is happening in Syria. Everybody is concerned. But as prosecutor of the ICC, I have to say we are not intervening in Syria because we simply don't have jurisdiction to go there.
Yes. The reason for my question was that there are misconceptions all over the world about why the ICC has not acted. As an aside, for the last 2 years, I've been teaching a course, International Criminal Justice, in China. The students are bilingual. I get the feeling that they know more about the Rome Statute and international criminal justice than a lot of people in our country. I'm just curious, by a show of hand, raise your hand if you have read the entirety or parts of the Rome Statute. This is a good...
this is impressive.
Good crowd.
This is impressive. This is a good
crowd. Yes, I'm glad I asked the question. Yes, right. So, Justice Goldstone, given the importance of accountability of all involved in the Syrian conflict, I'm going to ask you a question about Syria. What do you think should be done in Syria? Should it include accountability for international atrocity crimes occurring in Syria?
Well, clearly the Syrian situation for the last almost 4 years has been crying out for investigation for the very horrible war crimes, international crimes that have been committed on both sides, but particularly on what I've read by the Syrian government. And there's no doubt in my view that the Security Council has been remiss in not referring the Syrian situation to the International Criminal Court. I was interested, and to an extent, if it happens, relieved to read in the last week that France is proposing to put a resolution to the Security Council referring the Syrian situation to the International Criminal Court. Russia may or may not veto, but if Russia exercises its veto, let it take the responsibility for the continuation of war crimes being committed in Syria. For some years, I've been concerned about a practice that's grown up, particularly amongst the permanent 5 members of the Security Council, that the threat of a veto is paralyzing. In 9 cases out of 10. One of the permanent members threatens to veto, and that's an end of the resolution. It's not put. And I believe that's a practice that has been adopted by the permanent members to avoid them having to exercise their veto and put their foreign policy and their reputations on the line. And I believe it happened with Kosovo. It's happened time and again. And if the bluff is called, I believe that some of those vetoes will not be exercised, even though they've been threatened. And I'm not sure that Russia will want to be in a position where it's notorious that these war crimes have been committed. Perhaps it's not the best time to put Russia to the test with the Ukraine situation as it is at the moment. But at the same time, if Russia wants to veto the investigation into what the whole world knows are serious international crimes, let them do so. And it's no reason, I believe, for the French government or for the United Kingdom or for the United States not to put a resolution for referring Syria to the International Criminal Court. Clearly, let me add that domestic transitional justice mechanisms are going to have to await the peace. You can't expect and anticipate that there's going to be any serious investigation into war crimes in Syria while the war continues to rage.
I had not intended to make this session in part a survey, but I'm going to ask you to raise your hand. Those of you who think that the advice that Justice Goldstone has just given us should be followed, which is bring a resolution to the Security Council and let Russia do what it's going to do. How many of you think that should happen? How many of you think that's not a wise course? Okay, I see 3 hands negative and the other 300 positive. So if anyone at the UN is listening to this group, That was the vote. Now, the first question that I will ask each of you to address. There are those who claim that the pursuit of justice, whether it be by the ICC or the other tribunals, can in fact impede the cause of peace and be counterproductive. This is the debate, peace versus justice. Are justice and peace mutually exclusive, or are they reinforcing?
I think that it's really about time that we move away from you have to concentrate on peace first before you think about justice. We really, it's time that we move away from that and to look at the two, peace and justice, as mutually reinforcing. They don't exclude one another. And what we should do, I think, is to try and look for ways in which we can make both of them work. And this is possible. I strongly believe that this is possible. That is where we need to be thinking towards, and not thinking that we have to sequence justice or we have to take justice off the table because we are talking about peace. If you look at the Office of the Prosecutor, and I'm thinking in terms of the Uganda situation. In the Uganda situation, the office requested for warrants to issue against the top commanders of the Lord's Resistance Army. And if you recall at the time, I think Uganda was trying to encourage those in the bush to come out, and take advantage of the amnesty that was offered by the Uganda government. And the office was able to publicly announce, trying to reach as much as possible those in the bush, to say that these are the ones that we need. The ICC has targeted, and these are the ones being prosecuted. But those of you who are not should take advantage of the amnesty that is offered, come out of the bush, and take the offer that the Uganda government is giving. I think this is demonstrating first and foremost that the intervention of the ICC does not mean that other avenues should not be explored. Avenues for peace or any other way that it is felt that can be used for peace and security to return to Uganda. So, in short, what I think is that we have to realize that one does not exclude the other. It's mutually reinforcing, and when we try to intervene in these situations of conflict and do our part, whether it is justice, whether it is humanitarian aid, whether it is peace negotiations, we should try to see how we adjust to one another and work as a team towards achieving security, instead of trying to sequence or trying to prioritize.
Justice Goldstone.
Well, let me start by making a concession. I think one has to accept that in some situations, at least in theory, the investigation of war crimes may inhibit peace negotiations. It could happen. It's not difficult to imagine a situation where that might happen. I don't know of a situation where it's happened. It's also important to recognize that the two ad hoc tribunals were set up by the Security Council by making the link between peace and justice. If the Security Council in 1993 and 1994 had not made that link, it wouldn't have had the jurisdiction to establish the two tribunals. And I say that because it set them up, both of them, under Chapter 7 of the United Nations Charter. And they were set up as peace, as institutions, as mechanisms to restore peace and security in the former Yugoslavia and in Rwanda. And they did, to an extent. They worked as institutions that assisted bringing an end the war, certainly in the former Yugoslavia, and helping Rwanda come to grips with what happened to it, and to put an end to many of the fabricated denials that emerged out of Rwanda in the immediate aftermath of a most terrible genocide. Denials not coming from the people of Rwanda, they know what happened to them, but denials coming certainly out of France and Belgium and other countries who ascribed the killings to tribal differences and spontaneous combustion in that African state. What the international community, and particularly the United States, has to decide is, are we better off or worse off by having a system of international justice? Are we better off or worse off by withdrawing impunity from war criminals? If we're a better world, and I have no doubt that we are, then if a situation might arise where justice might impede or delay peace, that's a price that has to be paid. You can't have a little bit of international justice. You've either got a system that operates or you haven't. You can't turn it on and turn it off at will. So it seems to me that in most cases, and let me say in conclusion on this question, if it hadn't been for the indictment of Karadzic in 1995, in just less than a year after the prosecutor's office opened in the former Yugoslavia, if Karadzic hadn't been indicted, there would have been no Dayton meeting. There would have been no Dayton agreement, because Karadzic would have been entitled to go there. Because of the indictment, he would have been arrested by the United States and sent to The Hague for trial. And the Dayton meeting brought an end to the war in the former Yugoslavia. Nobody knew this. It's just the way the dice happened to fall in that situation. So this is one concrete example of where justice assisted negotiating peace. As I say, it might happen the other way, but that depends on how the dice fall.
I'm going to ask you one more question. Okay. The audience, raise your hand if you think that justice should yield when there are opportunities for achieving peace. Delay justice in the interest of peace. 2 votes. I'll ask, there may be abstentions. How many people think that the prosecutor's job is to prosecute and achieve justice and let others deal with the peace issue? Raise your hand. Raise your hand if you abstained from voting.
Your questions are confusing. You ask one question and then another.
I think this is an intelligent crowd. I think they got it. Yes, Tom.
It seems to me it's heavily dependent on that situation.
Of course.
Prosecuting Iranians for war crimes, all these negotiations on nuclear issues.
Okay.
But it's important to note Article 16 in the Rome Statute. The prosecutor should follow the evidence. If there is a political issue, it should be the counsel who relieves the prosecutor from that responsibility.
Right.
The counsel can intervene.
Okay. I think what this demonstrates is that this is one of those issues that there are strong feelings on both sides. I think in this room there was, by hand count, I think people instinctively, I think, believe that justice should be pursued, with the caveats that there may be those times when you need to sit back and let other things happen. Let's move on. The next question has to do with another misconception about the ICC. The court has been accused repeatedly, loudly, of primarily targeting Africa or having an African bias. The court's current docket shows that all of its cases at the moment are involve African perpetrators. Is there any validity to these claims? What is the response to those who accuse the court of targeting Africa?
This is a question that I always take very seriously, because I think it is wrong. It is a wrong accusation. It is unfair, and it is not based on the facts. Simply put, it's not based on the facts. And I think that we keep forgetting the need and the support that Africa has shown to the court from the time of its establishment to now, even with all the difficulties that we are confronted with, and I'll explain that later, but also the leadership that Africa has been showing in trying to advance accountability and the rule of law. We are really underestimating that. And I'll just step right back to the time of the establishment of the ICC. The role that African states have played, those who are involved in it know the role that African states have played for this court to be established. The first, I've said this several times, but I think I need to repeat it also all the time, because the criticism is not going away. And as I said, not based on facts. The first African state, the first state to ratify the Rome Statute is an African state, Senegal. And the first request that we have received for the intervention of the ICC all come from African states, all of them. The review conference, the first review conference of the ICC was hosted in Kampala. I think these are the issues that are very important for the existence, and the evolution of the court, and we tend to disregard them. I think we need to recall that the cases being in the ICC is a matter of jurisdiction first, and also it's a matter of request coming from African states. And quickly, just to give you the statistics, it's 8 cases, that are before the ICC. 5 out of those cases were at the request of African states for the court's intervention. 2 were at the request of the UN Security Council for the ICC to intervene. It is only in the case of Kenya that my predecessor has used proprio motu powers to go to Kenya to investigate these crimes. So if you look at the statistics, you will see that it is Africa, really, that is showing need for the intervention of the court in those countries, and it's showing support and leadership there. Some of the officials, some of the leaders in the court today hail from Africa. And we are very much concerned and very much worried about the peace. We care deeply about the continent. We are very much concerned, we're very much worried about the peace, the stability, the security on the continent. Of course, elsewhere, but hailing from there, we are concerned about that. And we believe that this can only happen if these crimes, these serious crimes that are being committed, there is accountability for them. This is a point that I want to raise. So, not based on statistics, we're having these criticisms. Come to the ICC, that ICC is only targeting Africa. ICC is, and again, I always say this, there are crimes. These crimes are being committed. It's critical what is happening on the continent now. The victims of these crimes are Africans. They're African victims. Mm-hmm. And I think they also deserve the protection of the law. There has to be rule of law on the continent for there to be security, for the victims to be heard. If we focus on protecting the leaders or those who perpetrate these crimes and forget about the victims, I also think that the responsibility that has been given to us under the Rome Statute, we are not fulfilling, and we are not fulfilling well. So it is wrong. It is based on
Misconception.
Misconceptions. It's based on misconceptions, but it's also used, to target the court. And it is not also only up to the officials of the ICC and those who work for the ICC who should try to correct these misconceptions. I think it is also incumbent on the states parties, on civil society again, on international organizations to assist the court, in outreach and in explaining what the court can do, what the court cannot do, why the court intervenes here and not intervene in another. Because the court, definitely we cannot do it alone.
Right.
That is for sure. And this accusation should go away. Should go away, but there are people who have interest that it stays. So the court needs help.
Just, I want to hear your response, but before, you just reminded me of something, Madam Prosecutor. About 3 weeks ago, there was a program at American University on the Kenya ICC issue. Maybe some of you were at that program. What I learned as moderator of that program from the individual on the panel who was speaking to the issues that Kenya has. I learned, for example, that Kenya, the leadership, for the last 12 months or longer, has engaged in a very expensive public relations effort to undermine the ICC, to cripple the ICC. I learned, for example, that the Kenyans are accusing the ICC of not only tampering with witnesses, bribing witnesses, torturing witnesses to give false testimony. And as moderator, of course, you have to be neutral. That's my role. But when I heard these things coming out of this individual, I was debating whether I should comment, and I did. I said, do you honestly believe those things that you just said? That the ICC would bribe witnesses, would intimidate witnesses, would torture witnesses? Come on. But there were people in that audience who believed the PR program. And what the prosecutor just said is very true. It takes education, and the court can't do it. We can do it. We are.
There's evidence of that. I mean, you could take live witness testimony. So it's not. This is not a clear situation.
Evidence of what?
There's evidence of, at least in the case that you and I spoke about as you came in, there is evidence of undue influence, of coerced statements, and of torture, at least psychological.
Torture by whom?
What is the evidence? When you say
Register?
all right, let's take. Then you'll have an opportunity at the end during the Q&A to be more specific. Okay. All right. I want to hear from Justice. I think we all want to hear from Justice Goldstone. His take on.
Well, let me say. I'm not going to speak in competition. Excuse me. I'm not going to speak while you're speaking. So. The point I would make is, and I'm sure it'll ring a bell. When did the African criticism of the ICC begin? When did it begin? There was, as Madam Prosecutor says, support from African states. In fact, still today, and as an African, I'm proud to say that Africa is still leading the pack in the UN regions for numbers of countries that have ratified their own statutes. But the criticism began with the arrest warrants issued against leaders.
President Bashir.
With al-Bashir. Before al-Bashir was indicted, there was no criticism from the African Union and African leadership. And it's reached a crescendo with the case going on against President Kenyatta and Deputy President Ruto. It's the leaders who are feeling the pinch. If you go to civil society, whether in Kenya or Uganda or South Africa or in the Gambia, you'll get civil society organizations, and particularly victims organizations, are all supporting the prosecutions. And there is a gap growing in on this issue between leaders and the people. And the leaders are protecting themselves and not the interests of their nation. And for that reason, it's my view that if there was next week 3 non-African situations before the ICC, this criticism is not going to go away, because it's not factually based. It's an excuse, it's not a reason.
Okay. Another issue that came up at that program at American University, which was co-sponsored by the American Bar Association, so that when the prosecutor says that civil society and NGOs have to speak out, I think she makes a good point. But another issue that came up was immunity for heads of state. I learned before that program that in 1997, Kenya was one of the 15 members of the UN Security Council. And in 1997, there was a unanimous vote by all 15 members that heads of state immunity should not be recognized at the International Tribunal level. Well, more recently, the Kenyan leaders have disavowed that position, saying there should be head of state immunity. Do you want to comment on that issue, either of you?
I think the fact that at the very highest level we can hold people accountable is very important for international criminal justice. If this goes away, I think it's a failure on the part of it. It actually setting us back maybe 100 years, that you cannot hold those who are at the highest level, the leaders, you cannot hold them accountable, and that they should have immunity. I think one of the main reasons, main purposes of having the International Criminal Court and having international criminal tribunals is to be able to hold those who we know that at most times in their own national jurisdictions cannot get them. And it is an institution like the ICC or the ICTY that is able to do that. If that goes away, it is setting us back, it is setting international criminal justice back 100 years, at least.
I agree.
Okay. All right, this question has to do with ICC-US relations. Those relations have improved notably in the last several years, starting with the second term of the Bush administration and continuing and accelerating during the Obama administration. In your opinion, what are the reasons that U.S. ICC relationship should be enhanced even more? And what opportunities for enhancement do you see?
Well, I can't exaggerate the importance of the role that the United States has played in furtherance of international criminal justice. I would go so far to say without the United States, we wouldn't have a system of international criminal justice at all. It was the United States that pushed for the ad hoc tribunals, which was the beginning of a new era. It was the United States that pushed for the International Criminal Court and encouraged the then Secretary General Kofi Annan to call the diplomatic conference in Rome. As the first chief prosecutor of the Yugoslavia and Rwanda tribunals, I can tell you that even if they'd have been established, they would never have got off the ground without the assistance from the United States. Government support, the American Bar Association, the CD program, we wouldn't have had fair trials if CD hadn't intervened in the first trial of Dusan Tadic. So it's been a hugely important contribution. The role of the United States judges, of Judge MacDonald, Judge Wald, Judge Moron, has been crucially important. And again, speaking from my own experience, the role played by United States prosecutors in the Office of the Prosecutor was hugely important. They really led the office when it came to investigations and the quality control to which I've referred. And if you look at the list of prosecutors who've led the prosecutions in virtually all of the important and high-profile prosecutions, most of them have been led by seasoned and well-trained United States prosecutors. The furnishing of intelligence information from the United States, remarkable. The United States intelligence community hates sharing information with the United States prosecutors. They fear that their methods of collection are going to be compromised. It was thought impossible that they would share information with an international prosecutor coming from South Africa. And yet that has happened and continues today with those tribunals. And I would be surprised if it's not already happening in some cases with the International Criminal Court. I think the United States needs to withdraw further some of the unpleasant legislation that was passed during the first term of the George W. Bush administration. There's still legislation on the statute book, and it was referred to earlier today, the so-called Hague Invasion Act, and other legislation that is still on the statute book and should be removed. And I don't believe it would be difficult to convince both houses of Congress to do so. It certainly shouldn't be. So the role the United States has to play has been certainly at a different pitch during the second half of the administration of President George W. Bush, and goes even further, as we heard earlier today from Ambassador Rapp during the first and second Obama administration.
Madam Prosecutor.
Just taking on from there, I think that we have seen this evolution of the relationship between the ICC as an institution and the US. And I just want to mention specific events, why I think this is the case, coming from the unsigning until now. And I think we can describe, I believe they describe themselves like that, as a cooperating non-state party with the ICC. But, you know, particular things make me say that. I think the calls that the US has been making for the arrests of individuals, you know, that are wanted by the ICC is one of them. I think they have been very clear and unambiguous. But also, you will recall that recently, the Rewards for Justice program, which always used to cover those indictees that are wanted by the ICTY and the ICTR. In April of last year, this has been extended to the fugitives of ICC as well, you know, giving a very handsome reward for information leading to the arrest of this individual. I think this is also a very positive development. And talking about the concrete assistance that we have received, the arrest of Bosco Ntaganda, or the surrender of Bosco Ntaganda. You know, many states were involved in assisting the ICC, but the United States in particular and the Netherlands were very instrumental in facilitating the transfer of Bosco Ntaganda last March from Rwanda, which we know also is a non-state party, to the ICC. These are concrete things that have been done. Also, for the hunt for and search for Joseph Kony of the Lord's Resistance Army, I think efforts are being made. The U.S. is concretely assisting, you know, for the search and the arrest of Joseph Kony and the other leaders of the Lord's Resistance Army. So these are things that make you see the evolution, you know, of the relationship between the ICC from the time of the bilateral immunities agreements moving forward until today. And I hope that the relationship will be, you know, even reinforced, you know, because I think it is also good for the court, you know, as an institution, that we continue to receive this kind of help. On the issue of ratification, of course, I never comment on any state, you know, or try to justify why any state would want to ratify or not ratify the Rome Statute. I do not think that this is an issue that I can address, but I only express my hope and my wish that, you know, more and more states will continue to join the ICC. I believe it's a strong message in subscribing to ending impunity, you know, wherever it happens. So that's fine.
You trigger a thought in my mind, and I'm going to try to ask a question that will not require you to talk about ratification. But as Mr. Hale indicated at the outset of this program this afternoon, the American Bar Association ABA-ICC Project exists to convene educational programs like this to discuss for the benefit of all of us what the Rome Statute provides and does not provide, how the ICC functions and does not function. One area of great worry and concern in the United States, certainly in our Congress, and even among the people throughout the country, is the conception that if the U.S. were a state's party, that a high-ranking official of the U.S. could be investigated, indicted, and tried at the ICC. Now, those of us who teach the Rome Statute know that that's highly unlikely to happen. But there are those who think it might happen under the Rome Statute. Do either one of you care to comment on whether that worry, that concern is a justifiable concern? That is, the investigation indictment of a high official of the U.S. being tried at the ICC?
Well, clearly it's highly unlikely for a number of reasons. Firstly, it's only the most serious international crimes intentionally committed that comes to the ICC. And the prospects of those crimes being committed by any democracy is unlikely. It can happen, but it would be an unlikely scenario. If it were to happen, the system of complementarity, it seems to me, would be a complete answer. The United States, if it had the legislation, and this is something that it hasn't sufficient, but if the United States seriously intended itself to investigate any crime with which an American citizen was charged, an American national, that would rob the International Criminal Court of jurisdiction, which has often been said it's a court of last resort, not first resort. And the prosecutor, the first thing the prosecutor does in a situation like that would be to ask the country of nationality of the potential defendant whether it wants to investigate. And if it does investigate in good faith, regardless of the outcome, that's the end of the case. And the International Criminal Court wouldn't have jurisdiction. So I agree with you that it's an unlikely scenario.
Any comment?
I agree.
Okay. Well, I have one more question before we open it up to the audience. And when I was thinking about the final question, my first instinct was to ask the question, imagine the world without the ICC. Imagine a world where there is no institution that will deal with the evil side of human nature. Imagine no court to deal with the atrocities that we see coming almost like an assembly line. Who would serve justice? Who would protect the victims? But I chose not to ask that question. Instead, my final question is to both of you, how do you envision the ICC 10 years from now?
I think the court, despite the many challenges that it has faced, continues to face, is maturing. It's maturing or has matured into an institution that has become a relevant player in international relations. And for the next 10 years, what is important, what is crucial, is that we continue to establish that credibility. it is important for ICC to establish its credibility and to continue to be the nucleus, of the international criminal justice system. This is important. Of course, we will need the support. We have to have the support for us to be understood, to be better understood, and for us to know, for people to know why this institution was set up. You mentioned in the question that you have not asked, that if the court were not here, what other institution is going to bring accountability to ensure that justice is done for the victims? Of course, the ideal that we all have envisaged in creating the ICC and the system of complementarity is that in time, national systems would also be able to take up and investigate by themselves these serious crimes. Because I believe it was my predecessor who said once that if the ICC is really functioning, it probably should not have a case, because that means national jurisdictions are also investigating and prosecuting these crimes. But I think there is still a long way to get there. From what we have seen happening in the past, it's a long way that we should get there. So we need this institution credible, doing its work in an impartial, in an independent way, at least for the next years, but an institution that can be looked up to be there, to be able to bring justice as it should, without fear, without favor, without politicizations, and independently working as we should.
Justice Goldstone.
Well, I agree. I'm an optimist, but I'm a pessimist in one area, and that is with the continuing commission of war crimes. I don't know how many of you visited the Museum of the International Committee of the Red Cross in Geneva. There's a pillar for every year since the International Committee of the Red Cross was founded in the 1860s. There's not a single year when there hasn't been a war in which at least 10,000 people have been killed. Not one year from then until today. And I can see no reason, in fact, there are unfortunate reasons, increased populations, global warming, increased numbers of people not having enough food to eat, not enough work to do. And these don't help in avoiding the commission of war crimes. So I've no doubt, unfortunately, for Madam Prosecutor and your successors, the amount of work is not going to lessen. Yeah. I fear it's going to increase, and I would love to be wrong. And more resources are going to have to be found. And to answer the question you didn't put, Mr. Greco, if there wasn't an ICC, it would have to be invented very quickly, and it would be. And I think perhaps that's a good note for me to close.
Thank you for answering my unstated question. Is there anything else either of you would like to say before we turn it over to the audience question?
I think we can receive the questions from the audience.
All right, I'm going to make a request of you. We have 35 minutes. I see a lot of hands. My requests are twofold. Number one is ask a question, don't make a statement. These are questions, not opportunities to give a speech. Please, make it brief, and let's see if we can get as many questions as we can, and the answers will be as brief as possible. So I'll start at this side of the room. Yes. Identify yourself.
Hi there. Thank you very much for this fascinating presentation. My name is Matthew Simpson. I'm the former legal advisor to the Darfuris who participated in the peace talks and facilitated Abu Ghraib's surrender to the ICC. My question touches on the Peace First Justice issue and cooperation. What relationship do you envision and do you think is appropriate for the ICC to have with peace processes and the institutions that are running a peace process, and with the peacekeeping forces such as UNAMID and other peacekeeping forces that are on the ground? What role do you see the ICC playing in those processes, and what relationship is appropriate going forward?
Do you care to comment?
One or several? We take one question only or several?
Should we take several at a time? Okay, let's take 3 or so, and then we'll go. Just to be fair, that gentleman, and then to this side. 2 from each side. Oh, we're ending at 5:30.
Yeah.
I'm sorry. My mistake. We're ending at 5:30. Call it 5:35. Yes.
Thank you very much. I'm Harry Ray from Florida International University. Madam Prosecutor, you mentioned in one of your challenges, in fact, the first challenge is the lack of resources.
Yeah.
With that said, I think it's agreed that we would like to see a Security Council referral for the situation in Syria. Based on Security Council referrals 1593, Sudan, and Security Council referral 1970, Libya, based on those restrictions, Madam Prosecutor, would you welcome a Security Council referral for the situation in Syria?
Okay. We'll take one on this side, yes?
Thank you. 2 brief messages, one from Kofi Annan and one from Mutula Kilonzo, former Minister of Justice of Kenya. And I'm not speaking, Hans Corell is my name, in my capacity as UN legal advisor, but advisor to the African panel of eminent personalities dealing with the Kenya National Conciliation and Dialogue. When I was the legal advisor there, I spoke to several high-level people at Kofi Annan's request under 4 eyes. One of them was Mutula Kilonzo, the Minister of Justice. He was adamant about the cases being brought forward before the ICC. There's no way we can deal with him in Kenya. The other cases could be dealt with by the High Court. We discussed that. Mutula Kilonzo died a year ago under very mysterious circumstances in Kenya. I still don't know the result of the autopsy. Kofi Annan, on 7 October last year, he gave a lecture in South Africa. And after the lecture, somebody asked him, what is your comment about the heads of state meeting in a few days in Addis Ababa, discussing to withdraw from the ICC? His answer was, they deserve a badge of shame. He's a great supporter of the ICC. And if you let heads of states off the hook, you've destroyed the whole idea of the ICC. Thank you.
Okay, let's deal with the questions that have been asked.
I think the first question was the relationship between, ICC and negotiators for peace. I just want it to, of course, I'm sure you know, to be clear that we have our different mandates. Ours is justice. Ours is investigations and prosecutions. They have their mandate, and which is peace. And I do not think that we should at any time be seen as being involved in peace processes. We are not, and I don't think we should be involved in peace processes. But that doesn't mean that we are not sensitive to what they are doing. I think it's also important. At the end of the day, what we all want to achieve is to bring back security, bring back stability to whatever region that we are acting. But I think our mandates should continue to be separate, and where we can exchange information, that is not confidential, that will not in any way interfere within the legal framework we are working with, we will of course do that, if that is going to assist. But it has to be clear that ours is a justice mandate. We are not peace negotiators, and they have their mandate, we have ours. With respect to Syria, it's a very difficult time, for me to make comments, whether it's about Syria, in this case about Syria, or any welcoming or rejecting anything that the UN Security Council is doing. What I can say is that as an office of the prosecutor, we do welcome referrals from UN Security Council wherever they may come from in the first instance, but we also have to be clear that referrals from UN Security Council does not automatically mean that the ICC will take it, the office will take it and investigate. Of course, we still have to do our preliminary analysis of whether the crimes fall within our jurisdiction, whether it's in the interest of justice, and all those things that we do in the preliminary phase. So a referral by the UN Security Council also does not automatically mean that we will take it. So I would refrain from welcoming or rejecting anything that the UN Security Council is doing at this current time.
The point of my question was the lack of resources and support.
The lack of resources, definitely, if we need, even currently as we are, without any other referral coming, we still need additional resources. And I think we have been clear about that. You know, so anything that would be added to the case docket now, we definitely would need to have additional resources to be able to deal with it.
If I can just add one aspect of, refer to one aspect of resources, I think it's highly regrettable that the price that the United States insists on making for Security Council referrals is that the United Nations may not pay 1 penny towards the investigation of a reference by the Security Council. The United States said, if you don't want us to veto, any references from the Security Council have to be paid for by the International Criminal Court, and that the United Nations will not contribute. And I think that's a very, very unfortunate and unfair policy.
Okay, it's a minute or two after 5:30. Someone help me. Can we take one more two questions? Let's take 2 more questions, and then we'll end with those 2. So I see your hand first. Go ahead.
I'm John Washburn, convener of the American NGO Coalition for the International Criminal Court. My work is to promote the cause of the ICC in the United States. My question goes to the prosecutor. There has been a great deal of loose talk around, including, unfortunately, some of it at the ASIL annual meeting this morning, that the Kenyatta case is dead, that you will not be able to produce the necessary evidence, that the postponement to October is simply a lead-up to a dismissal of the case. I realize that you suffer from limitations in discussing this issue, but within those limitations, I'd be grateful for anything you could tell me that we could use in our advocacy.
The final question I'm going to accord as a matter of respect to Ben Ferenc. Please.
Last but I hope not least, I'm Ben Ferenc, the sole surviving Nuremberg prosecutor. I'm 95 years old, and I'm hopeful that the young people here will be able to create a more peaceful world than I have lived through as a combat soldier and as a liberator of many concentration camps. My question specifically is, in the light of what has been discussed here, isn't a practical answer greater emphasis now on the complementarity principles in the statute by encouraging the national jurisdictions to begin to prosecute the cases which, for one reason or another, financial or otherwise, are very difficult in the international court. And if we can build up a groundswell among the national jurisdictions, wouldn't that encourage the big powers to go along, or at least the public in the big powers, to begin to put a little heat on?
Okay, those are the 2 questions. Your comments.
I think the question on the Kenyatta case, I mean, from the beginning of this case, you know, there has been a lot of speculation about the Kenya cases, and people have taken different, conclusions, made different conclusions about the case. But I think I have been clear, my office has been clear, that we are proceeding with this case, or any other case for that matter, based on the evidence that we have. What we collect is what we will present to the judges. When we are satisfied that this evidence will make our case. It is very important. And you will note that last year, I had to ask for the adjournment myself, because we made a reassessment of the case, and we saw that with these 2 critical witnesses leaving the case, no responsible prosecutor should go with the state of that case before the judges. You know, I think it is not right. You know, it is not ethical even for me to do that. And this is why I have been very clear and very upfront with the judges. I have requested the judges for additional time. For additional time, I've requested for the trial to be postponed to a later date to explore some avenues which were not available to me at the time, you know, which we also thought have become available. We're having difficulties still with them, but we are pursuing them. But this is just to say that as a prosecutor, I think that whatever is in my power to be able to do, to present before the judges a credible case, should be done. Should be done, and it is only when I do not have that evidence any longer that I can rethink my strategy. And this is the process in which the offices, I think we should stop speculating that this is a precursor to ending the case and that it's collapsing. We're trying to keep the case. We're trying, but we can only do as much as our evidence allows us to do.
Okay. Do you care to comment on that question? And then the last question that Ben Ferenz asked. Any further comment?
About national complementarity. I mean, complementarity, we know, is one of the fundamental, you know, principles of the Rome Statute. And as I said earlier on, I think we should, the position that the office has taken towards positive complementarity, you know, has been clear. An example is Guinea. You know, we, apart from the statements that we have been making, we have also been encouraging, you know, Guinea to continue to try to investigate and prosecute by themselves. This is the same situation with Colombia. This is just to say that where we are able to encourage national systems to do so, you know, we will continue to do that. You know, because intervention of the ICC, as we all know, is the exception. It's not the norm. You know, but again, you realize that with countries like Guinea, even though they may want to do it by themselves, sometimes they really lack capacity. And this is why I'm thinking that states have to think of how they can assist those states that need the assistance to be able to investigate and prosecute themselves, and not leave it to them alone to sort it out. They should have assistance really from other states. I recently met with very high-level authorities from Guinea. You know, in fact, it was the president, because I had written a letter to say that the ICC has been following this case for the past 3 to 4 years, and not much progress has been made. But if nothing is done, we are going to step in to investigate. And I received, again, assurances from the very highest level that all the steps that we've agreed that they should do to show at least they're doing something meaningful has been done, and that I received a promise that this will be done. So it's not only that states are lacking in will, but they may also lack capacity. And we need to think as states how we can help them to be there. Because as I said, if national systems work well, if they function well, then all this burden that is coming to the ICC to investigate and prosecute everywhere will be lessened.
Thank you for being a member of this panel. Thank you, Justice Goldstone. Thank you for attending. Join me in thanking our speakers.
Thank you all very much for being here. We want to thank the Coalition for the International Criminal Court, Kip Hale of the ABA-ICC Project for organizing this, and all of you for being here. Thank you so very much to Madam Prosecutor Bensouda, to Lord Goldstone, and to our moderator. And thank you all, and please join us for cocktails. We're going to try it outside. It may be a little windy, but we'll see.
Yes, I sent you an email.
Good.